Hello, everyone. Hopefully, you are all now in the webinar. Welcome to the CAPS Information Law Update webinar. I'm Andrew Latham, and I'm really pleased to be doing the session this afternoon. We have, I think, 200 or so signed up people on the webinar today. So hopefully, there's going to be some content in the course of it that is going to be interesting and useful for everyone. The webinar is going to be recorded, and we'll share the link after the event's taken place, and you can then share that with colleagues if you'd like to. There are various kind of chat boxes that are open to you, and if you experience any technical problems, then you can use them to raise them with our support team. I'm delighted to have Serena, my colleague, on the webinar with us, and she'll also be looking at the Q&A box and also running some polls during the course of the webinar. So if you've got questions as we're going along, then please do type them into the chat box, to the Q&A box, and Serena will then synthesize them and pass them on to me. And we'll try and operate on a kind of Chatham House rules basis. So the fact that you have made a question won't be repeated in the webinar, but we'll pass on the content in an anonymized way to share with everyone else. The feedback from the webinar is really, really helpful for us in terms of looking at what to do next. And so after the webinar, you will get a feedback form as well as the slides. Please do complete it, and please do let us know if you've got anything that you would like to raise as a result. The things that I wanted to cover today is a general kind of update on case law and issues and guidance for the last sort of 12 months or so. I appreciate probably people have been working their socks off for the last year, and there might be a few things that are sort of peppered throughout the recent history of information law, which might be of use. We're then going to look at DPIAs in a bit more detail, because there are a number of issues that have arisen in the last 6 months, particularly with coronavirus, which have given rise to questions about when a DPIA should be done, what a DPIA should include, and also there's recent case law on this as well. So I think it's quite a timely occasion to be looking at data protection impact assessments, as well as the kind of glamorous end of new information law issues. We'll double back and look at the things that are the more sort of bread and butter issues. So subject access requests, which remain a challenge, and some thoughts on how to make life easier with those, and also with freedom of information requests. I know the ICO has said that they are respectful of organisations needing more time to deal with subject access requests and freedom of information act requests, but I think the ICO is now starting to look on a more even keel with information law requests that you might be receiving, and so some top tips to make sure that requests that you're dealing with at the moment are done right and in a way which hopefully avoids internal reviews, ICO complaints, or a trip to the tribunal. We'll also just have a look at some risk management issues that are coming up and some points for the future. But as I said at the start, the real point of this webinar is that it's for you. So if there are questions that you've got, then please do type them in the chat box. Please do let us know what's keeping you awake at night. And as I say, we won't attribute it in any way to any given organisation unless you really want us to. And we'll do our best to answer things either Q&A style throughout the webinar, or alternatively, if it's something that we can pick up afterwards, then we'll do that as well. I've tried to make this a webinar which is interesting in terms of the content, but lawyers love making text-heavy and unexciting slides. So I thought I'd get my picture out of the way of something interesting happening. So there is a horse being fed a sandwich by an astronaut there, just to try to break the ice a little bit. So we'll move on from the fun slides and into things which are probably a bit more text-heavy, but hopefully it's then a resource that, coupled with the slides and coupled with the recording afterwards, you can look back on down the line if you would like to. So, as I say, what I wanted to do to begin with is just do a run through of some recent case law guidance and issues affecting the health sector on information law. And some of the themes from that, I think, actually pan through into the other issues that we're talking about over the course of the rest of the webinar. This time last year feels a very long time ago, but there were a few things which were starting to bubble up this time last year, which have had a bearing on where we are now and where things may lie going forwards. And if we look back to August 2019, we see a fairly significant fine from the Swedish data protection regulator for a school that introduced a facial recognition system to run its registers, and that was found to be deployed in an unfair and ill thought through way, and they got a fine as a result of that. Around the same time, in the UK, there was a court case concerning South Wales Police, which has got a facial recognition trial system that it has been running called Locate AFR. And the court looked in that case at whether or not the arrangements were lawful and whether they were subject to sufficient safeguards. And this was a High Court case. And the court said, well, actually, yeah, we think that that's an okay set of arrangements, and that the DPIA, whilst not fully completed, was completed to such a degree and in such a way that the High Court was satisfied with it. We'll double back to the Court of Appeal case, which came out at the end of last month in a little bit, but there are a couple of sting in the tails from the more recent Court of Appeal case. The ICO launched a revised data sharing code, or at least a draft data sharing code, in September last year. I think it's worth having a look at that from time to time, not least for the section in it on what should be included in a data sharing agreement, and it's worth double checking whether your agreements adhere to the code and keeping tabs on that. In the health service itself, the control of oversight of information governance is something which has been sort of bouncing around a little bit for the last few months and last couple of years, and into the mix comes the revised National Information Governance Board, which met in October last year, and also in October, Lloyd and Google, a Court of Appeal case, which says that damages can be in principle awarded for loss of control of data, even if there isn't really a pecuniary loss that's suffered and there's no real distress to the data subject. So we're starting to see, and this will be a theme which I'll come back to, I think, an increased environment for litigation and sources of remedy for information rights breaches at the moment. So if we look back to the sort of middle 2010s, we start to see, off the back of the Vidal Google case, the prospect that damages are recoverable for distress arising from data protection breaches. And now the Lloyd case goes a little bit further and says the mere fact of loss of control of data is enough to give rise to a claim. Also, around the same time last year, in terms of civil procedure, there was some new rules for data protection and other privacy-related claims. And as well as these kind of high-level issues that we're seeing in the last year or so, it's also business as usual, and people making silly mistakes or unfortunate mistakes happening, I suppose is probably a better way of describing it. And unfortunately, North Devon NHS Trust managed to set the Trust's default answer machine message as a patient's voicemail message for about 7 hours, which caused quite a lot of news attention as well. Around the same time, a perennial question which comes up is, can patients make recordings of clinical consultations, and is it okay to do that, and does it comply with GDPR? Mustard and Flour is a case concerning that very issue, and the court said, well, if the patient is making that recording for their own purposes, then it's okay. It's not a legal problem for compliance with GDPR, and it's not particularly a nice thing to do to make a secret recording of someone, but it's not an illegal thing to do. And I think there's a couple of takeaways from that as a case. So it's worth bearing in mind that any interaction between you and another person, or you and a patient, or you and a member of staff could be being recorded. In other words, it's practically very difficult to stop a recording being made. But I think it is worth having for your organisation a policy on circumstances in which making recordings is more or less appropriate. So, for instance, it's probably less appropriate to make recordings in public areas of hospitals where other people could be in earshot or in sight, or where interactions touch on third parties, or where recordings are being made vexatiously. I think it's also really important that staff have training on facilitating recordings, and that there are communication skills workshops with service users and other people that might want to make recordings. And also, last but not least, that there is signage and leaflets and guidance for service users on when they can make recordings and how to make a good recording. Around the same time, NHSX and guidance on AI in the NHS, which is worth having a look at. And we also see at the back end of last year the first actual concluded monetary penalty notice under GDPR. Is it for £100 million against British Airways? Is it against Marriott Hotels for a similarly large amount? No, it's against a pharmacy that left some records in a shed and was in trouble with the MHRA as well. And they got a £250,000 fine as a result of failing to secure the records that were in place. And as I say, the high value monetary penalty notices that the ICO has threatened are still not concluded. Finally, last thing from the back end of last year, new subject access request code of practice that the ICO consulted on. Moving into this year, and we'll briefly talk about coronavirus as well, but things that were in the courts, ABC and St George's. This was a sad case, and it was concerning a situation where a patient had Huntington's disease, and he didn't want his daughter, who is ABC, to know about this. And ABC became pregnant, and the patient X refused to let his clinicians tell ABC that he had Huntington's, Huntington's is a hereditary disease, and there was a risk that ABC and her unborn baby would also develop Huntington's as a result. And X knew that this information would impact on whether ABC would continue the pregnancy or have an abortion. And sometime down the line, ABC came to learn of her father's Huntington's disease because one of X's treating clinicians accidentally disclosed the fact that he had Huntington's to her, and that was after ABC had had a baby. And ABC then had a genetic test which confirmed that she would develop Huntington's in due course. And the question was, should the clinicians have told her about the risk of Huntington's in the face of a refusal from her father? And the court says it's really important for clinicians to undertake a balancing exercise between the third party's interest in being informed of the risk and the patient and the public interest in maintaining confidentiality. So this is right at the heart of the 7th Caldecott principle for people that are familiar with those. The balancing exercise that needs to be taken doesn't go as far as expressly including a duty to warn. So you mustn't take away from the case that you must warn in every circumstance, but there are circumstances where that balancing exercise could fall so far in favour of disclosure that a failure to tell someone could give that person the right to bring a claim for a data protection or failure to notify, failure to warn of a risk that was faced by the patient. That could have been controlled if the disclosure was made. Also in February, NHSX published its digital health technology standards, and that's worth having a look at. And then also in the courts later in March, this was a case concerning a patient who'd been to a private counselling service, and Scott was the patient and the LGBT Trust was the counselling service. Mr. Scott told the service about mental health issues and substance misuse issues, and specifically said that he'd had some thoughts of self-harm. And the assessment that was made by the LGBT Trust was that Mr. Scott was at intermediate risk of self-harm, And the LGBT Trust then specifically informed him that due to concerns about his welfare, they were going to discuss that assessment with his GP in order to help him get some further support. And they also said that Mr. Scott didn't need to consent to that disclosure because of the nature of the concerns that the LGBT Trust had about his welfare. And Mr. Scott didn't really complain about that at the time. Before he even had the appointment, he'd previously signed a consent form or an assessment form that made clear that information may be disclosed in those circumstances. And the LGBT Trust then spoke to his GP and provided details of the risk assessment that they'd been made. And then Mr. Scott then sued the LGBT Trust about the breach of confidence and breach of the DPA. And the court said, well, the disclosure was made over the phone, therefore it was done verbally, and therefore this was made prior to the coming into effect of GDPR, but the DPA and GDPR didn't apply because it was solely a verbal disclosure. And it was also justifiable, even if the DPA, GDPR, did apply by reference to the various legitimizing conditions in the law. And additionally, the general duty of confidence that Mr. Scott was owed had been qualified by what had been said to him by the LGBT Trust and the form. So, you know, they'd given him fair warning that they would be providing that information to his GP if they had concerns about his welfare, and that's what they did. And so his expectations had been managed by the clinical team. And in any event, the disclosure would have been justified in the public interest. So this is a really useful case in terms of disclosure onwards of confidential information, but also a useful case in bringing the patient with you on the journey, even if they don't like the outcome that is reached. Finally, in March, coronavirus came home to roost, and on the information law side of things, there were notices made further to regulations concerning whether or not the duty of confidence applies to information which is being disclosed for COVID-19 purposes. Those are very broadly defined. I'm not going to go into mega loads of detail on the notices themselves, and I would suggest that if you're interested in this as an issue and what the notices do or say, Andrew Harvey, who is a doyen of healthcare information governance, has got quite a accessible and well-written article on those issues, and you can find that on his LinkedIn. Moving on to spring, other things that were floating around, GMC guidance and NHS guidance on information governance issues arising from remote consultations. Worth having a look at both of those from a clinical perspective and from a information governance perspective. A case that I don't like at a personal level, Re-AB, which concerns a personal representative's right of access under the AHRA. And the court said that a personal representative has a broad right of access to information under the AHRA than simply records that are actually needed to manage the patient's estate. So under the AHRA, there are two rights of access. One is for personal representatives. One is for people that have a claim arising from the patient's death. And the claimants in that second category only get to see the records that are relevant to the patient's, to the claim that they've got. But the personal representatives, the former category, have a broader right of access. I think a lot of our clients are faced with issues where someone might be a personal representative, but their motivations of seeking to access people's records may not be wholly pure. And I think this is a case which actually raises more questions than it answers, because if you're faced with someone who is a personal representative but is trying to access records which they perhaps shouldn't see, then whilst there are still some exemptions in the AHRA which can be applied to those circumstances, they're not quite as clear-cut as the exemptions that simply those records aren't relevant and therefore they don't get to see them. So I don't like that as a judgment, but I'm not I'm not the judge, unfortunately. So that's that. Finally, Reed and Price. You probably know the names Alex Reed and Katie Price, or Jordan. She was formerly known, and Jordan was trying to, or had some salacious videos of her former husband, Alex Reed, and was threatening to disclose those to various people. And Alex Reed sued her as a result of that, and he got £25,000 in damages for the malicious sharing of private photos or information about him. And that's actually quite a useful case in terms of demonstrating some of the upward measures of damages that we're starting to see in information law cases at the moment. And the court makes some interesting comparisons between a psychiatric injury and severe distress, which Mr. Reed was suffering from the disclosures that were being threatened. The big case this year, and one that you're probably familiar with, is Morrison's, which concerned another malicious use of information, and that was a circumstance where a former employee of Morrison's sought to blackmail Morrison's because he was cross with them from an employment perspective by stealing his colleague's personal data and posting them on the dark web. Morrison's spent several £1 million trying to put the situation right and doing right by their employees, but they were then faced by a group action from 5,000 of their employees for failing to keep their information secure and also being responsible for Mr. Skelton, the employee who stole their information. And this was a case about whether Morrison should be responsible, vicariously liable for the malicious data breach that Mr. Skelton had perpetrated. And the court looked at this as an issue and said, in the circumstances, it's not fair to impose a duty on Morrison's for Mr. Skelton's actions. It's not fair for them to be responsible for that. Mr. Skelton's conduct wasn't so closely connected with the acts that he was authorised to do for his work, processing people's payroll information for audit purposes, that it couldn't be said to be fair or properly regarded as done in the course of his work to use that information and put it on the dark web and expose the individuals and Morrison's to a loss as a result. So the motivations that Mr. Skelton had were an important factor there. And that's, as a case for data controllers, it's kind of good news, because if you've got good measures in place to prevent a data breach and those are deliberately circumvented by an employee, then you shouldn't be responsible on a vicarious liability basis for them going rogue in that set of circumstances. I think what's important to take away, though, is that data controllers still need to have appropriate security measures in place to satisfy your own obligations under data protection law. The court also says that data protection law doesn't provide a blanket exclusion of the vicarious liability principle, even in the case of rogue employees. And depending on the fact, actually there could be circumstances where vicarious liability could still attach to a employer for a data breach. So good news for Morrison's, generally good news for data controllers, but not wholly out of the woods. Finally, one last case, and again, illustrating some of the direction of travel in damages. JQL and NTP concerned a dispute within a family where someone put some stuff on Facebook, and that caused some distress to one of their relatives. And in real inter-family dispute, one member of the family sues the other, and £15,000 damages as a result. Into the summer, I think it's worth having a look at the One London Local Healthcare and Records Exemplar Report on Information Sharing. It's useful for the Caldecott Principle review as well, because one of the new Caldecott Principle, or the new Caldecott Principle that's been suggested, is a duty to inform and be informed by a patient's expectations about how their information may be used, something which we also saw in some of the case law that we looked at earlier on. That consultation has just finished, and we will wait to see whether or not there is a new Caldecott Principle that is brought in as a result. Other big cases, European case, Schrems. If you are sending data overseas, and in particular, if you're sending it to America, you cannot use Privacy Shield anymore as your basis for sending data overseas. The European Court of Justice goes a bit further as well and says the standard contractual clauses or model contractual clauses may not provide sufficient protection on their own for international data transfers, and you need to think about the laws of the country in the place where the data is going and what in practice could happen to that data in the third country rather than simply relying on the standard contractual clauses themselves. I think kind of points to take away for the health sector there: try and UK onshore your data if you possibly can. This case could have a bearing on what happens post-Brexit and whether or not there is an adequacy decision. And there remains a headache about how you send data from a European data processor to a UK data controller, and conceivably a EU data controller might conclude that data isn't safe in the UK, applying the judgment of or the principles from the judgment of Schrems 2. We will have to see what happens with things like the internal market bill and other issues that are currently before Parliament. So we will see how that plays out. A couple of last cases: Bridges in South Wales. I mentioned this earlier on in the High Court, where the South Wales Police use of automatic facial recognition was found to be lawful. Off it goes to the Court of Appeal, and they give their judgment in August. And the Court of Appeal says, well, generally facial recognition can be done lawfully, but actually South Wales Police didn't have enough controls in place around how some of the data was being used, or where the automatic facial recognition was being deployed. And the court also looked briefly at the DPIA as well and said, well, it started from a misconception because it didn't understand that there weren't enough restrictions in place on where the AFR could be deployed, and therefore technical knockout on the DPIA itself. But actually, this is probably one of the few cases at the moment where there has been some judicial scrutiny of data protection impact assessments, and we'll look in a few minutes' time at what the court concludes around where those can be applied. And one last case, just to bring you up to date, a judicial review case against two foundation trusts concerning the deletion of inaccurate information from medical records. A very sad set of facts concerning a young man with autism who may have been looking at some inappropriate photos, and some information was passed by one trust to another about that, and it was alleged that that information was inaccurate, or inaccurately described what he was doing, and the first trust then followed up and said, actually, this is what we think happened. So they provided a correction, but the patient, via his mum, wanted the records to be deleted. And the court looked at this and concluded that actually it's fine for the, in inverted commas, inaccurate information to be retained in the records, providing that there are adequate notes of the corrections to any inaccuracies. So I think that is almost certainly what most NHS organisations do, but it's very reassuring to see that the court takes the view that that is the right thing to do. I'll just pause there. I don't know if there's any questions, Serena, from that gallop through the last year or so of information rights law issues.
Yeah, so we've had a couple of questions through, and we've had 4 so far. So one of the first ones was about video meetings and recordings. So where there's a video meeting that has several different patients attending, how is it possible to protect all patients if one of them makes a recording and shares it publicly?
Good question. I think that is a good example of where laying the ground rules is really important. And where information about other patients is being discussed, I think that would be a good case to say, well, actually, we can't carry on with this consultation whilst you're making that recording. And certainly if you put it, or if we know that you're going to be putting it on the internet, if all of the patients are fine with it, then I think it's a slightly different different scenario. But if someone is putting stuff up onto YouTube or whatever else, or onto Facebook, then that is probably not for domestic purposes anymore. And there's a case called Boyvids, which says if that's starting to stray away from personal usage of data. And the mustard and flour case is saying, well, actually, if all you're using it for is for your own purposes, then that's outside the scope of data protection law. Boyvids says if you start putting it onto the internet, then that probably is in the scope of data protection law, and the patient would have responsibilities as a data controller to handle that appropriately. You can use YouTube to take down facilities to get stuff removed, and I would also strongly recommend sending a strongly worded letter to the patient, getting them to take it down. And if people would like advice on that, then it's something that we'd be very pleased to help with.
Brilliant. And so there's one of the other questions was around what the outcome was in the ABC and St George's case.
So the outcome was that the court held that in that case, the approach that the trust had taken was right. They've done the right balancing exercises, but it's really important that there is a demonstrable balancing exercise where there are competing rights for disclosure, and the weighing up of the factors on either side is carefully documented. There is a little briefing note on our website about the case, and I'd suggest that I'll send that out after the webinar, because that talks in detail about the conclusions that the court reached.
Brilliant. And there's a few other questions that come through. So one is around LPAs and access to medical records. So what to do where a trust receives a request from a patient's representative who holds a finance LPA for access to medical records. Is it okay to look at that on a case-by-case basis, or is the general view that that's reasonably acceptable?
I think look at it on a case-by-case basis, but make a best interest decision. So if there's no suggestion that they are accessing the information inappropriately and there's nothing inappropriate in the records, then it probably would be okay to disclose it. But I will think about that in slower time, because I think it's probably, as with other situations, quite fact specific.
Brilliant. And there's just two other questions. One of them relates back to the recording issue that we were just talking about. So what to do where there's a secret recording for staff member who's making derogatory comments about other staff. So how to deal with that in terms of a disciplinary procedure, grievance procedure. And the final one is just whether or not there's any revised contractual clauses following Schrems 2 for use in the NHS.
I'll deal with those back to front. There aren't any yet. There are supposed to be some at some point, but wait and see. The recordings by a staff member done in secret, I think they're generally admissible. Like if you wanted to use them in the course of a disciplinary hearing, you could do, if they go to the heart of what is a disciplinary issue. There is a second question about whether that exposes the employee that has made the secret recordings in breach of a trust policy not to make recordings to a risk of a disciplinary hearing themselves or disciplinary issue themselves. Should they be told off for not making secret recordings and encouraged not to make secret recordings in the future? Probably yes. But as to whether or not you could then use them, I think you could. I'm just conscious of time, so we'll trot on to DPIAs if that's okay. And we've got a couple of poll questions, which hopefully will appear on the screen presently. And I'm just interested to know, on a gut feeling basis, how confident you feel in undertaking DPIAs, and whether that at a kind of personal level or at an organisational level. And please do chat away in the chat box around that as an issue. and then when we've got some votes, then you can we'll see what the feedback is. It's a bit like pointless, isn't it? It's very exciting doing polls. I'm intrigued to see how this plays out. So Serena, can we see what the answers are?
Yep. So currently we've got 90 people who have 91 people. I'm currently at 59% yes and 41% no, but it's still going on.
Fairly half and half. Well, should we wrap up that poll if we can and move on to the next poll, which is a similar question in a different way around do we do the right number of DPIAs? So fairly half and half that people feel confident in doing DPIAs. Do people feel confident that they're doing the right number of DPIAs, Serena?
So we've got about 18% who are saying they're doing too many DPIAs, and yeah, about 41% and 41% who are saying they're doing about the right number and not enough DPIAs.
Interesting feedback. Thanks. So I was thinking about DPIAs, and as I say, there's something that's in the news quite a lot at the moment around test and trace, around A-level results, and I thought, well, what makes a good DPIA? So I did what I think most people do, and did some Google searches, and I looked for good data protection impact assessments on Google, and there are 8 hits for good data protection impact assessments. I then tried searching for excellent data protection impact assessments, and there are no results for excellent data protection impact assessments. And last but not least, I thought, well, what about effective data protection impact assessments? And there are a few more hits for that, but actually it doesn't really pull up that many examples. So I'll come back to a question about what I think a good DPIA looks like in a bit. But just as a reminder, when to do one and what is one. There are statutory requirements to do them in certain circumstances. It's worth certainly, if you're not sure about whether or not you should do one, to have a look at the European Data Protection Board guidance on high-risk processing and when to do a DPIA. And I can ping you a link if you need a copy of it. But it's I think sometimes there's a focus on viewing it as a document. And I think that's actually the wrong mindset to have. It's not just a document. It's a tool and it's a process that results in a document. And if you're going to do it, you need to do it before the processing is done. But obviously you need to also do it sufficiently far into a process that you can sensibly assess the risks that are likely to arise from the processing that's taking place. And it's really important also to keep them under review, both in terms of the development stage of the project that you're engaged with, but also I think and at risk of making work off the back of a project being completed. But I think it is worth thinking about whether or not the risk assessments that you have done for any given project have borne out in practice, because actually that also helps to shape your view of where the risks may be for other projects that you're looking at in the future. I think the wording of the legislation isn't brilliantly helpful around when to do a DPIA. You've got to do one if it's a high-risk data processing activity, but what is high risk isn't actually defined in the GDPR, and how do you get to a point of concluding whether or not something is or isn't high risk without first assessing the risks, which is doing a DPIA. So I think the wording of the legislation in this bit of the law isn't brilliantly clear, and I have total sympathy therefore with the 40-odd% of people that said that they weren't mega confident in when they needed to do one. And also, we've seen the range of feedback on whether or not people think they're doing too many, the right number, or not enough. So I think this is something actually where it would probably be helpful for there to be better guidance from the ICO, EDPP, or indeed within the NHS on when to do one. And obviously a lot of organisations have screening questions on when a DPIA needs to be done, and it's worth flowing through those in terms of a project. I think also, if in doubt, do a DPIA. I think sometimes there's a tendency to sort of shy away from data protection risks or privacy risks and implications of a project. And even if your conclusions are that actually this is a low risk activity, it's helpful to have the audit trail in due course. And there have been a number of cases recently where a DPIA hasn't been done, and that is one tool or one lever that's then used to go after the organisation in question. So as I say, I mentioned test and trace earlier on. One of the earlier iterations of test and trace, there were concerns that there wasn't sufficient transparency information, there wasn't sufficient impact assessments about what had been done with that, A-level results as well. And actually there was a kind of 200-page document on the A-level results algorithm, which sort of was a DPIA, but it wasn't brilliantly clear that that's what it was. And it is something that is picked up on by data protection advocates, privacy advocates, or people that are generally opposed to what's going on, or have an interest in what's going on. So I think if in doubt, do one, because it might, particularly if it's a contentious project or an idea. In terms of some practical issues, who does it? Well, I think it's important to think of a DPIA as a team effort. Both internally but also externally. Do you actually have to reinvent the wheel? Is it worth having 200 different data protection impact assessments for introducing Office 365 in the NHS, or actually, could that be pooled at a more sensible level across organisations, or drawing down from a central template rather than everyone doing their own thing? Some of the DPIAs that I've seen, I think sometimes there's a tendency to pass the responsibility for completing it solely to the person that's like the project manager for the project, and they may not have any training or any experience in doing this kind of thing in the past. So I think it's important that there is some hand-holding with people that are tasked with completing them, but also going back to the team effort point, internally, do you need to draw in technical expertise from your IT team or your clinical teams or whatever else in terms of completing the DPIA? And perhaps actually it should be the organisation's IG team that's seen as the kind of project manager for the DPIA process. I suspect that that's going to lead to some negative feedback on the feedback sheets, but we'll see what plays out on that. I think it's also worth bearing in mind that your DPIA might need to fit into other assessments, so your equalities impact assessment, and also bear in mind that if you're an NHS trust or an NHS Foundation trust, you've got obligations to involve patients and the public in service changes or changes to the way in which services are delivered. And if you're a CCG, then you've got obligations to involve the public in commissioning decisions. And if you're rolling out a big bit of new technology or a new way of doing things, actually it's possible that if you're doing kind of public consultation, public engagement work under those statutory duties, there would be a way of feeding in feedback from those processes into your DPIA for a project. Say if you're moving, I don't know, all of your clinical services online, that would probably trigger your 242 duty, but also it might feed into your DPIA as well. In terms of which template to use, think about who you're writing for, and also what you're going to be doing with the DPIA in the long run. I've put there Goldilocks zone. I see some templates for DPIAs that are, even before any content's been added, 30-odd pages long. And I think that feels slightly overbearing. So it should be not too long, not too short, and relevant to the project which is in hand. And the other thing, and this I think goes back to the training question, is if you're using the ICO's template, there are a series of questions in the comment box, in the template, and there's a few DPIAs that I've seen which don't actually answer those questions. And I think if you start with answering the questions, then that puts you in good stead for the completed DPIA. And a reminder to myself, as much as anything else, to allow sufficient time in your process for the DPIA. Some good news around what the court might look at if they're looking at your DPIA, and what level of scrutiny might they apply to a DPIA. And this was from the Bridges High Court judgment, where the High Court said this was an okay DPIA. And they said it could have said more, but it was still found to be lawful. The court isn't going to interfere in terms of substituting its own views for the data control. So as long as your assessment is sensible, then and you've adopted a reasonable line of inquiry in conducting your DPIA, then that's probably going to be enough. So as long as you have applied your own expert knowledge, conscientious assessment, then the court should be slow to interfere with that DPIA where it's been done. That being said, Bridges Court of Appeal said that the DPIA on a technical knockout basis didn't do everything that it absolutely needed to do. It didn't consider something that the court said it had to. And so it's worth having a look at that as a judgment. I've just pulled out some of the relevant phrases there. So what did the DPIA do? Well, it acknowledged that this was a project that might be privacy intrusive. It explained that the use of automatic facial recognition would only be lawful if it was necessary and proportionate and aiming to discharge a legitimate aim. It explained how the system operated, and it also stated that actually the entire point of this as a project is to capture as many people's personal data as possible. So it embraced the challenge of privacy-related issues or data protection-related issues that was inherent in the processing of data under the facial recognition scheme. So going back to my earlier point, I think it's worth not downplaying data protection-related issues. So that leads to my original point, as what does a good DPIA look like? And I think actually the South Wales Police DPIA is good. You know, it's worth looking at. If you're stuck for one that could be a template, and obviously it might not be wholly relevant to NHS-related issues because of the subject matter, but in terms of something that has been interrogated by the courts, it's a useful exercise. I think it's also worth having a look at the test and trace DPIA, which is pretty long and pretty technical, but is up online as well. Finally, I think a couple of other points. The risks with a project aren't just going to be, we might lose the data. I think sometimes I see DPIA and the kind of main risk that's focused on is the loss of data. And I think it's important to bear in mind that there are risks from projects going right, as well as risks of projects going kind of catastrophically wrong. And also, I think it's worth bearing in mind that actually you're coming from a starting point where you've got good information governance in place in the first place. You know, you're doing a toolkit assessment, you've got all of the systems and processes in place to get data protection right. And so it's important to bear in mind that you've already got a load of mitigation associated with your project by virtue of the way in which you're working. So don't forget to downplay those. And then the last point there, don't downplay, join up your documents with other tools. And then I was also just thinking about kind of new ideas, and if you're coming up with a new project like test and trace or whatever it happens to be, how does that apply, or what questions should you as a data protection practitioner in an organization or someone with an interest in information law related issues think about? And I think as a starting point, what are you actually trying to do? And then as a second question, does what you're proposing to do actually do the thing that you're trying to achieve? So there was all of this shenanigans with the first test and trace issue, where there was a suggestion about, do we have a decentralized model, a centralized model, or whatever else? And in actual fact, the centralized model was a complete non-starter and didn't achieve the thing that they wanted it to achieve. So then they've had to roll back from that. And then the following question, can we achieve the same thing in a better way? So I think that's worth bearing in mind. The follow-on, there's a ground of challenge. why aren't we doing that either as well or in addition or instead of the thing that we're actually planning to do? And then can we show how we've thought about those issues? Who benefits from what's going on, and who might be, does everyone benefit? Who might miss out? Why might they miss out? And what happens if other people don't think like we do in terms of the project that we're looking at? What are we doing about them? So those are some kind of extra thought points which I think tie with DPIA related issues. I'm just conscious of time, and I'm just going to charge through, if that's okay, some of the subject access request points and FOI related issues. And I've probably been ambitious with the amount of stuff that I've sought to include here, but I'll just run through these very quickly. Just as a very quick poll that we can maybe run in the background, I don't know if people would like to say how many SARs they're getting now, and whether they're expecting to get more or less than they had before. Do complete that at your leisure, and I'll just carry on talking while people are voting. But I think just some case law as a quick run through. Can you make a subject access request when you're bringing a claim against an organisation? Yes, you can. Lots of cases that apply to that. Can I make a subject access request during a disciplinary process? Yes, I can. There's no specific exemption for the fact that you're engaged in a disciplinary issue. It might be relevant to mixed personal data questions, management planning and negotiation, but there's no special exemption for disciplinary issues. And so you need to think about and work in conjunction with HR colleagues and information law colleagues around the relative timings of the SAR and the disciplinary issue and what comes when. There have been a number of questions about disproportionate effort. It's worth bearing in mind that it's a high threshold to show disproportionate effort, and that means that you need to be able to show evidence about why you're doing what you're doing and why you're not doing what you're not doing. Organisations that have taken a kind of all or nothing approach, you know, it's all too difficult, therefore we're not going to comply with the SAR at all, are ones that have got into trouble. But that being said, there's no duty to leave no stone unturned, and the case law kind of reflects that as a set of issues. The ICO has looked at the way in which organisations have complied with subject access requests and have focused on that as a policy area for enforcement in the past. They're one of the monetary penalty notices under the DPA was for disclosing the wrong information in consequence of a subject access request, and an organisation didn't have any policy or training on the SAR response process. So take a look at the learning from the Regal Chambers monetary penalty notice. And what to do if you get a painful one. Do your searches, look at the search results, remove the duplicates and irrelevant information, think about the third-party information, think about what other exemptions might apply, keep a record of what you're going to disclose, and so you've got a copy of what you're giving out as well as the information that actually gets disclosed. Serena's got the feedback from the poll results. Broadly, people think status quo in terms of subject access requests, but actually, you know, no one's saying that they're going to be getting less, and 34% of people think they're going to be getting more. So if you're expecting busyness on subject access requests, it seems that that's a theme that's going to be shared by colleagues. Moving on. Keep a record of what you're giving out and what you're withholding and why. And remember that there are obligations to provide other information as well as the disclosure of the information that's held. So if you're going for gold star compliance, make sure you're covering off in your subject access request template response letter all of the other things that Article 15 GDPR requires. And some thoughts about how to get rid of a painful one. Can you funnel down what information the data subject is actually interested in obtaining? Always ask the question, I think. If you can get them to be more specific, then so much the better. What are the easy wins? So what can you disclose quickly and readily so that you can show that you are trying to deal with the requests and showing a positive positive attitude to information rights. We deal with a lot of requests relating to HR-related issues. Generally, the content of someone's HR folder is going to be disclosable pretty much in its entirety. If you can get that out the door fairly early on, having looked through it, then yeah, so much the better. Don't hold back on the easy wins whilst you're fretting about the difficult stuff. So it's worth thinking about, could you disclose information in phases in order to get the easy win stuff out, and then at least you're giving something to the data subject rather than holding on to everything for the back end. As I say, why are you drawing the line where you're drawing it? Why are you saying that what we're doing is reasonable and we can't do more because it would be unreasonable to do more? So some evidence to back that up is helpful. Have a second pair of eyes look over the information prior to giving it out, particularly if it's contentious, particularly if there's lots of redactions in it, because certainly I find that you get to a point where you can't see the wood for the trees anymore. So it's worth having someone else have a look at the information. And the perennial problem isn't the content of information, which is genuinely exempt. It's the information which you're going to have to disclose, which is someone calling someone else a rude name in the course of an email. So sage advice from Judge Judy: dance like nobody's watching, email like it's going to be read out in court, and remind your colleagues of that, particularly now where everyone's doing stuff on Teams, everyone's doing stuff on instant messaging systems within work and things like that, and on work WhatsApps and things like that, and that potentially is disclosable as well. Finally, subject access, the information requests, and one last poll for you here. Are you getting more or fewer requests than those which you had before? Are you expecting more or less? Do add those to the poll. And just again, while we're waiting for the answers to come in, a couple of extra questions or a couple of extra comments from me rather. The ICO has recently published a self-assessment toolkit, which is a series of quiz questions on their own website, and it's worth having a go at that if you've got a spare 15, 20 minutes, and it can provide some useful feedback on how you're getting on. In terms of the number of requests that the ICO is getting, it's about the same, or the number of complaints that they're receiving, it's about the same. And it's also worth having a look at, and this is where that table at the bottom is drawn from, the ICO's trends and feedback from members of the public, which are showing broadly stable patterns in terms of people's right of access to information. So I think what's interesting here is probably a parallel with the subject access request. The most popular category is that the number of requests is going to be about the same as what it was pre-coronavirus, and then a sizable minority are saying that the request might be up in the future. So thanks very much for the poll answers on that. A few top tips on free information requests. I can get my slides to move on. Requests that struggle, or responses that struggle rather, that I see are ones that haven't actually answered the applicant's question. The applicant's asked for X, Y, Z, and the answer says, thanks very much for asking for X, Y, Z. Here's the answer to ABC. And so particularly if the applicant is a journalist, it's worth making, or another concerned individual, it's worth making sure that you're actually answering the question, because people generally know what they're looking for, and they'll come after you if you haven't supplied the information that they'd like. A similar theme is an organisation decides that the information it's decided what it wants the response to be, but it hasn't applied that by looking at the information itself. So I think it's really important always, even if you're getting pressure from other departments to take a different approach, to make sure your response is led by the information itself. It can save you a lot of grief in the long run to make sure that your starting point is, well, what do we actually hold and what does it say, rather than what do we want the response to be. If you're going to be out of time, bear in mind you should be responding to requests promptly and within 20 working days. Keep the applicant up to date. The world will carry on spinning if you're out of time, but that things that are done in a hurry tend to struggle. Make sure that you can show how you've given advice and assistance to the applicant, and that can also include your any kind of contextual information that you want to provide to the applicant about what's going on as well. And if you're using Section 12 or Section 36, which require you to have an audit trail, make sure you've got those audit trails in place. So it's really important, I think, just to follow the requirements of the legislation to show how you're complying with the requirements of the legislation. A couple of other things that I see from time to time: responses don't confirm or deny whether the information exists, and that's a specific requirement. It feels like a kind of silly thing to say sometimes. If we do hold this information, but it's exempt, or we don't hold the information, full stop. So I think it's worth just making sure that you're discharging your Section 1 obligations, and also where exemptions are a question of would prejudice or would be likely to prejudice, you need to nail your colours to the mast on one of those. You can't have a response which is would or would be likely to prejudice. You've got to choose one or the other. And similarly with the public interest test, make sure that you're working through the relevant factors. And one last thing, always Google what your organisation has published already, particularly in its board papers, because from time to time we deal with responses and an organisation is trying to say that the information is exempt, but actually it's already published it or routinely publishes it in other resources that are made available. And I think it's worth bearing in mind that the way in which you respond to a request could become the story itself. The government managed to spend £40,000 on a information tribunal dispute about how often a minister went to the north of England, which he was responsible for. He'd been 10 times in the course of the 2 years that he was a minister in that particular department, and the cost of litigating the fact that he'd only been 10 times for £40,000, and they still lost. So yeah, choose your battles on this, I think, is important. And a couple of last tips on that side of things. If you're dealing with the ICO, do your homework. So use your internal review as a rehearsal space for the ICO response, and you can use the ICO's template questions, because the chances are they'll then ask them if you then get a complaint to the ICO in your internal response. The ICO isn't your enemy. To the extent that you have an adversary, it's the applicant. And so bear in mind that the ICO is an impartial and lay decider of the response, the validity of your response. So you might need to set the scene with them in terms of providing some context, particularly if you're using NHS acronyms in your FOI responses, or the response is at the end of a 3-year service reconfiguration and there's an enormous backstory to the request. So it's worth setting the scene with them, and it's worth picking up the phone if you want to. Have a look at the ICO guidance, have a look at their decision notices, have a look at the tribunal decisions, and if you want to offer informal resolution, then you can always offer it. And finally, if you're at the ICO stage, then think about whether or not you want to run multiple exemptions, and whether you want to focus your exempt information on the information which is really and absolutely exempt, rather than trying to blanket exempt entire documents. And last but not least, make sure that you're prioritising your absolute exemptions in preference to your qualified exemptions. A couple of last thoughts to take away. Do I think information law is more or less risky than before? I think it's probably about the same amount of risk, and I think the joy of this kind of work is it stays interesting and it stays relevant, and that there are challenges within it, and those come across from the fact that the law isn't clear. Some of it is very prescriptive, but a lot of it is pretty vague and agnostic about what you must or mustn't do. Some of the obligations that we've talked about are onerous, and it's worth making sure that you're discharging those fully. And why this is all risky is because individuals don't have to show very much if they can show that your measures have been insufficient in order to be able to get some money. Other risks, within an organisation and between organisations, the left hand doesn't know what the right hand is doing. There is a current enthusiasm for this move fast and break things approach from the top of the government, which sometimes works, but in information rights, I don't think it does. But you're faced with all of these novel challenges at the same time of all of your existing problems. I think there is a thing that actually, you know, people predicted doom and gloom when GDPR came in. That hasn't happened. The sky hasn't fallen in. But I think we are starting to see this slight kind of grating of small, low-value claims and people beginning to get on top of their rights, particularly when they're motivated by something else, like an employment dispute or another dispute with an organisation. All of this is set against all of the other pressures that you're under. What can we expect to see in the time ahead? Well, the dust is continuing to settle. There might be some more guidance. There might be a few more judgments. I think the courts are doing a fairly good job at the moment, and they're balancing some general rules and careful scrutiny of particular decisions. We're starting to see more cases coming through on damages. Unfortunately, the trend in damages is inflationary. And so we've seen some, you know, traditionally I'd have said, well, it's all 4 figures. I'm now starting to say it's 4 figures, 5 figures, and the numbers are creeping up. I'm not sure what the ICO is doing at the moment, and I'm not sure that they know themselves what they're doing, as in what their kind of current focus is going forwards. And so I think it will be interesting to see how that plays out, particularly at a time where the NHS in particular is doing things which are more sophisticated and moving quickly. And if you're doing these new projects, make sure you're keeping an eye on the fundamentals as well. I'm not sure I've given many answers, and I'm probably just adding a voice into the mix here. And one last thought to take away is one thing which has come up, which is, has the world moved on? You know, some of the things which has happened, having just said we've moved to a move fast and move quickly and break things approach. You know, one of the things that has certainly come up in conversations with people is the rapidity of progress that has been made, and that decisions have been made quickly, and things have borne out over the last 6 months and continue to work. And I'm not sure that, you know, we should necessarily roll back from some of those changes, but interested to know your thoughts. Thanks very much for joining us. Those are the comments. I'm conscious I've run over. If we've got a couple of minutes for a last couple of questions, then very happy to do those. But I'm conscious that people probably need to get off, and so please don't hesitate to get in contact with us afterwards if you'd like to do so. Those are our contact details. And Serena, I don't know if there's any other questions that have come up.
Yeah, there've been a couple. So there've been a few around SARS, DPAs, and some of the more general points we were talking about at the beginning. So in terms of SARS, one of the questions was, do you have to report to the ICO if you don't meet the subject access request deadline?
No.
And what to do where an applicant has requested paper disclosure rather than electronic disclosure? You can do around that.
I think you need to think carefully in that set of circumstances about whether it's a fight that is worth having. So if an applicant has given you a particularly good reason for why they want the information in an electronic format, sorry, in a paper format, say for instance, they have a disability, they don't have a computer, whatever it happens to be, then I think the path of least resistance is probably to provide it in a paper format. You potentially could try to recover an administrative cost from so doing, but the time of arguing about the amount of paper and the cost of postage is probably going to exceed the cost of the stamps and the paper themselves. So I think my view is ordinarily try and give disclosure electronically, try to encourage electronic disclosure because it's for the patient's benefit as well as yours. But if someone is determined that they want the information in a paper format, then I think it's probably easier just simply to adhere to that request than to have a fight about it.
And one of the other questions on SARS was whether you need to redact the name of professionals from outside your organisation, or are those classed as third parties?
So the Data Protection Act provisions that talk about this don't, I think, and I would have to check, say they describe health professionals. They don't describe health professionals working within the data controller. I would want to double check that, but I'm fairly certain that if it's a health professional, then their details need to be disclosed. If they don't work in the organisation, you might want to do the kind of courteous thing about telling them what's going on, just in case there is something external to your organisation that it would be helpful for you to know about, as well as for them to know about the fact that the request has been made. I should say, I think we get to see who's asked the questions, and so if there's anything like outstanding, I think we can probably give some quick answers to things after the event. So if we can keep those details, then I'll try to drop a line on that point.
I mean, there's three other questions, just one around DPIAs. So where you've got a data sharing initiative with multiple organisations, is one DPIA enough? Who should lead on it? How, what works well with it?
I think it would be a good idea to share a DPIA. Each organisation might want to make its own assessment of some of the risks, so you could have a DPIA in common. Or you could just have a joint DPIA that all of the organisations sign off. I don't think that is prohibited by the law, and I think it would be a good idea to share resources. As to who leads on it, I think that's the kind of thing that would need to be decided between the organisations themselves. But again, think about it as a team effort.
Brilliant. There's just two final questions. So one going back to the recording scenarios we were talking about at the beginning. So where an employee records their manager, can that be used as part of a disciplinary hearing? And can you discipline the staff member for recording their manager?
I think the answer to that is yes to both. Whether or not there is a breach of a implied duty of trust and confidence if you're making recordings of your colleagues surreptitiously or behaving in a way which isn't upholding your organisation's values. It's the kind of thing, again, I think probably where it would be worth an organisation thinking about having something which is a little policy document or something clear which you could hang the fact that recordings shouldn't be made onto. As to whether or not it's admissible, again, I think the starting point is, well, if it goes to issues that are relevant to the disciplinary case, then it potentially could be heard. It's for the chair of the disciplinary hearing to decide what evidence they need to hear and are willing to hear. But I think it's for the it potentially could be used in the course of disciplinary.
Perfect. So we've had a couple of other questions as well that have come through, but I don't know if it's better to maybe deal with those afterwards, or if you want to carry on going through them.
I think we might. I'm just conscious of the time because, as I say, I've been ambitious of the amount of stuff to try to cover in an hour. So it's been a bit of a whistle-stop tour. We can do a little report after the meeting, and if you've got questions, then please do pop them in an email to us. My details are on the screen. I think, as I say, you get the slides afterwards, you can get the recording afterwards. And so please do drop us a line if there's anything else. And thanks very much for joining us. And thanks, Serena, for fielding all of the questions. Thanks very much, everyone, and see you again.